It's a subject that we don't like to talk about. We put it on the back burner. We don't want to talk to our families about it either. It's just easier to put it off to another day, so that's what we do. So I'm talking about your estate planning documents, your will, your enduring guardian document and your appointment of an attorney. So today I'm going to shake your tree a little bit as a reminder of the consequences of not having these documents updated regularly or having them in place at all. So after many years of dealing with estate planning issues, I could write a book, I think, on the case studies of problems that clients have encountered. I call them my horror stories that result really from lack of planning and preparation. I'm going to share some of those with you too. So I love the Scout motto, be prepared. If there was more preparation at whatever age, it would result in a lot less stress and problems. There'd be a lot less work for the Supreme Court to do in sorting out family disputes. That's a very expensive exercise. So the result of proper preparation and planning would be a positive a positive result rather than a negative one. The statistics are that 50% of Australian adults don't have a will. Many of those who do have a will may not have updated it for many years. The executor or the beneficiary might have passed away, and this could result in the will being invalid or, the least, a partial intestacy. So I know it's difficult to face up to the fact that one day we're going to leave this earthly life, but there's nothing more certain, as we know, than death and taxes, so it's better to face up to it and do something about it. When you appoint an attorney, you're basically appointing a financial manager to look after your finances if you become incapacitated or you're just too ill to look after them. So they virtually stand in your shoes. They can keep the wheels turning, they look after your income coming in, they pay the bills. They can even sell property if this becomes necessary. When you appoint an enduring guardian, this is a person that makes decisions about your health and your lifestyle. You have to be totally incapable of making those decisions before this comes into effect. So the guardian can make decisions about where you live, sort of health care you receive, any other kinds of personal services, and consenting to medical and dental treatment. It is so vital that you discuss these issues with your family members because they should know what sort of medical treatment you do want to have or not to have in the event that you are seriously ill. You should also discuss those wishes in relation to your funeral, whether you want to be cremated or buried. I often get calls from clients asking me to have a look at their parents' will after they've passed away to see if those issues have been mentioned in the will, because they simply have not been talked about at home and they don't know what their parents wanted. Now, these matters that I've just talked about can also be recorded in what's called an advanced care directive, and my colleague Janine McElraith will be talking about that in the next session. So what happens if you don't appoint a guardian or an attorney? Now, this is where my horror stories come in. And I'll share a case, the first case with you, one that I found was extremely sad. But it does demonstrate a common problem that occurs frequently. Circumstances might be different, but the result is the same. So a gentleman came to see me to resolve a problem that had arisen for him. History was husband and wife both had a will, but they hadn't gone that step further and signed a power of attorney and appointment of enduring guardian. They jointly owned their home. The husband had super entitlements from which they were drawing quite a healthy, reasonable income. Then the wife was diagnosed with a terminal illness, and the time came when she was assessed to go into aged care. Husband would visit her every day, occasionally take her home for a meal, then take her back to the home. But after that, problems started to really arise for them. The husband was advised to make an application to the Guardianship Board to be appointed as his wife's guardian and attorney. Now, we often come across cases where there's a rebel child in the family. We all know those rebel people. They want to swim in a different direction to everybody else. In this case, there was a rebel daughter She was opposed to Dad becoming her mother's attorney and guardian, so she decided that she'd make an application herself. So there's 2 opposing applications. Now, in a case like that, where there's clear family conflict, the tribunal is very, very careful. They won't appoint either of them, so they appointed the public trustee and guardian. Now, that immediately took all control away from the family. The rebel daughter soon had the ear of the guardian and complained that her father's visits to the home were very upsetting to her mother, and this should stop. So eventually the guardian then prevented the husband from visiting, and he wasn't able to see his wife at all. In the meantime, the public trustee was requesting large sums of money for equipment that they perceived that the wife required. Thousands of dollars for an adjustable bed, fair enough, that was for her comfort. Finally, thousands of dollars for a whiz-bang wheelchair that he couldn't really understand why she would want that. She wouldn't have a clue how to operate it anyway. And this is the time that he came to me and he said, what can I do about this? I'm extremely worried that they're going to keep asking me for money and I'm going to have to sell the house to be able to pay all these bills. So we had a look at the options. And what we had to do, in fact, was to organise a family law property settlement. Parties had basically separated, and that's the only way that we could try to keep his assets or some of them intact. So the result of that was that the entire super entitlements were transferred to the public trustee to administer for the wife. He was able to retain the family home and he was then reduced to Centrelink benefits. So it was a very, very sad ending for everybody really, but it could have had a different income if they had been prepared before for that situation that eventually faced them. We don't have a crystal ball, so we can't look into the future, but at least we can be prepared in order to save a lot of stress and heartache in the future. Only a few weeks ago, a daughter phoned me for advice. She'd been a full-time carer for about 9 years with her mother. Mum was hospitalised after falling and breaking a hip, but she'd undergone rehabilitation and her health was starting to improve. And she wanted to go home, and daughter wanted her to come home. She wanted to continue to be her carer. But Mum had not appointed the daughter as her attorney and guardian. So the decision was made, no, Mum's not going home, Mum's going into care. So it wasn't the result that either of them would have wished for, but again, with planning and preparation, that outcome could have been quite different. I often get calls from people too who just ring to say, look, I've got a problem, can you help me with it? Mum, Dad's just had a stroke. They got into hospital, we've been told they're going to have to go into aged care. We do need to sell the house. What can we do? Well, have you been appointed a guardian or attorney? No, didn't do that. Well, sorry. But the scenario with the public trustee will then come in. So your estate planning lawyer is the one to talk to in relation to these specific needs. And he or she should discuss with you and draft the documents that are most relevant. Everyone's situation is different. Now, I've talked about rebel family members, and they can not only cause havoc but a great deal of distress within families, and especially as parents are ageing, they really don't need that sort of stress. And you've got siblings saying, well, I'm more able to take care of Mum's finances, so I should be the attorney. Or they're saying, Dad's not going into that aged care accommodation. I've found something that's going to be much more suitable for him. Or even going as far as to say, I should receive more than you from Mum's estate because I've always looked after her and you've hardly even come to visit her. Sibling rivalry that may have been dormant for years quite often comes to the fore when these decisions have to be made. And other problems can arise also in relation to abuse of the elderly in aged care, because none of the parties want to complain for fear of retaliation and perhaps increased abuse. So is there an easier way to resolve these disputes that especially cause stress to an ageing parent? Fortunately, more clients now seek mediation to try to resolve conflict and disputes, and for a number of years now the courts have used mediation to resolve issues in the early stage, to nip the problem in the bud between litigants. Mediation is a beneficial tool in these family disputes relating to aged parents, but currently in Australia this special field of elder mediation is not readily available. The USA and Canada are streets ahead of Australia in this area. So shortly I am travelling to America for intensive specialised training in elder mediation, because I can't get that training here. Once I come back, I'll be one of a very few people that are qualified to do the elder mediations. So resolving problems for clients has always given me a great deal of satisfaction. I trained as a mediator about 20 years ago, and I'm now really looking forward to putting this new training into place once I come back. Our population is ageing. The baby boomers are reaching their 70s, so this is really a growth area for mediation. So we'll be hearing a lot more about this once I come home. You can also read about it more on our website and on the back of today's program and other materials in your satchels. And Catherine Henry Partners now have a new website, agedcarelawyers.com.au, and that's a real go-to website for lots of information about ageing and aged care. So in conclusion, stop procrastinating. Come and see me if you feel that I can assist you to be prepared and to have positive outcomes. Thank you.